welcome to this 211th session of Letils. Today, we have a very unusual subject which is being addressed by the host of this platform, Advocate Shyam Padman. And to introduce the topic, we have Senior Advocate V.Giri of the Supreme Court, who was a former judge of the Kerala High Court. And sir, over to you for the topic intro.
Okay. Thank you, Prem. And Shyam, you should be congratulated for choosing a subject that's not very commonly debated, but it's a very relevant topic. It has great significance in the present day context of present trend of consumerism and overconsumption. Planned obsolescence usually involves a strategy on the part of the manufacturer of consumer products. That's one area of it. Of introducing a product that quickly becomes outdated to the extent of forcing its customer to upgrade or buy a new version of the same product. What comes to your mind immediately is the series of iPhones that I'm sure most of you would be holding in your hand, starting from the original iPhone to the iPhone 12 or X, which is currently in vogue. I think we have been part of this planned strategy that manufacturers of products must have, laid down or been indulging in. It's not an indulgence; it's a very planned, very, very well thought out program that the manufacturer of the product must have, thought about even before he launched the first version, or maybe after the first version, because he had to gauge the acceptance level of the product after the first version had come about. I'm just giving a very popular example. It probably holds true for many other consumer products that you see in the market, and which we are also consumers, willing consumers of that. It is a practice, and that is how it has been perceived. It is a practice of anti-consumerism that is predominantly seen in tech-driven consumer products. However, planned obsolescence is not a phenomenon restricted to your phones or computers. Laptops also, along with the iPhones, you have this. You get an iPhone, whatever is the version that you have today. Within 3 years, you get the market tells you that the manufacturer is coming out with another version, with an updated version. And probably once that is launched, it's quite possible that some of the software that has been already installed, it comes as the product along with your iPhone, may not work in the new one, or you have a better version. You have as quite dependent on the iPhone that you have or the product that you have, and there is a dynamic progression in the newer versions that come about, that you are compelled to shell out a whole lot of money to get the newer version. Take the case of a car manufacturer. It probably the iPhones are a more recent phenomenon, but then I think this is being done by the auto manufacturers for quite some time now. Take the case of a car manufacturer who introduced a model this year, only to pull it out of the market in less than half a decade. I owned a Hyundai Accent for quite some time. Maybe it doesn't happen from year to year, but there's no Hyundai Accent now. But then you have an offer from the Accent dealer, Hyundai dealers, saying that you come with your older Accent, and then we will exchange it for another version. We'll exchange it for another Hyundai model. Again, this is part of the planned obsolescence. For those who are familiar with it not only happened with the cars that were manufactured outside India. I think this was being done even otherwise. But therefore, what you do is that what they also do is probably withhold a key feature in the model in the newer, and introduce it in the newer version. That feature would have been perfectly possible to come out with that feature or introduce it even when the original version had come out. But you don't do it. for obvious reasons, you don't do it. And then you come out with this additional feature, which probably makes the car that you have been using it all along a bit more consumer friendly, user friendly. You are tempted to buy the newer version. Shyam, am I audible?
Yes, sir.
Suddenly I find that my
Perfectly.
screen is gone blank.
Perfectly.
Okay. This is only one among the several examples that I'm certain that Shyam, who's known for one of his several appreciable qualities, he would have done a great deal of meticulous research into the subject. And I'm only giving a very perfunctory overview of this topic, which Shyam would be speaking about in greater detail. And there could also be a positive impact of planned obsolescence. And Shyam, I'm sure that you would be touching on that also. This is better illustrated in the case of software used by corporations, government institutions, and banks, where cybersecurity practices demand that these institutions use up-to-date software that ensures optimal security of consumer as well as employee data. What is essential to be seen is whether in the Indian context, the interests of the consumer is protected by the legislative vernacular of the Consumer Protection Act. What Shyam would probably be touching upon also is a very pernicious danger of e-waste. And I don't know whether the manufacture of all these products that we now treat as part of our day-to-day existence, let alone cars, but I think iPhones and laptops and several other things, when you get updated newer versions, you will have to treat the earlier product that you have been using all along as a waste. You may be able to use it for a few more years, but ultimately they are consigned to the e-waste dustbin. It creates a huge problem. I don't think we have a legislative framework to deal with this extremely pernicious danger that is looming large, and I don't know whether as a country we have woken up to it. I can only think of the hazardous waste rules framed under the Environmental Protection Act.
No, e-waste management rules are there.
Yes, they are also there, but I think you require a parent statute, or maybe the existing rules are sufficient, but you require its implementation in a much more aggressive and comprehensive.
EPR has not been extended. Extended produces liability, but
yes, sir. Sorry, I must have. Before I said anything on that, I must have remembered that you are there. And therefore, one can't get away with these things, in a very glib manner. But over to you, Shyam. I'm only supposed to make the introductory remarks. I'm sure, Shyam, that you will keep us engrossed on a subject that is all very, very pertinent and relevant to the present day times.
Thank you very much, sir. I think the novelty of the subject is both my forte and my apprehension as well, because whatever I say, there won't be much of a debate over it, because all of us are equally ignorant, or rather not very sure about what is what. Idi Amin is said to have made a comment once, that is, you may have freedom of speech, but I cannot guarantee you freedom after speech. It is just like that. We consumers are made to believe that we have the freedom of choice, but there is no freedom after choice. One example that was cited by Giri sir, that if you purchase a car, not of it becoming obsolete, but you are tied like a dog to that service center that you cannot take it elsewhere. So if at all there is any change in technology, etc., you will be done for. So before I start my short presentation or sharing of my thoughts on this subject, let me first thank Justice Giri sir for the introduction and for agreeing to be present today. And the person who could speak both about consumer protection as well as environmental protection being his passion is K.Surendra Mohan sir. And I am indeed privileged to have you, sir, on this platform to sum up. So if at all there is any infirmities or if I do make some silly statement, I'm sure that it will stand corrected at your when you do the summing up, sir. And let me also thank Justice Ramkumar sir and Justice Ramakrishnan sir. And in fact, the presence of both of you gives me the courage to go ahead with this presentation. And like always, it is very easy to be the host, but when you're asked to speak, I know that this platform does not have any mercy on the speakers in the sense like they expect high standards, and that's what we have set for ourselves. I'm not very sure I'll be able to cater to that, but still, I may be able to introduce the subject for deliberation and discussion. Nowadays, I would also thank all of you for being present today, being a Friday, not a regular meeting day, but still your presence, I'm indeed indebted and thankful. Things don't last as long as they used to anymore, is the comment we usually hear. Whenever we talk about a refrigerator or anything, parents used to say, nowadays it used to last for years and years. Now you see these are, something wrong with it. What is wrong with it? Have you ever thought that there is something that is really planned, or there is a syndicate working behind it? We haven't. So today, like Giri sir started off by saying, what exactly is a planned obsolescence? I would say that there are different facets to it. Let us first examine. I structure my presentation today in this manner. I'll just give an overview of what the different nuances of obsolescence is, the international perspective, and the lack of a domestic law exclusively for this, but how it can be, the existing law could be utilized for the purpose if the way in which I would like to perceive it is acceptable. Let us see that. Two terms could be said to be associated with in the business practice with obsolescence. One is planned obsolescence, with which we'll be dealing with. The other is perceived obsolescence. The latter is easy to demonstrate, just like fast fashion clothing items, which are replaced every few months, smartphones that launch every 6 months, making earlier models old and redundant, not because they are inoperative or they cannot be used, nothing like that, because the new one make it much more lucrative. So there is a perceived notion of obsolescence or the earlier one becoming obsolete. Now, the objective here is to entice the consumer to buy the newer products, even though the products they are replacing with these impulse purchases function well. So that is one way of augmenting business. Then obsolescence is the process of becoming outdated or obsolete and no longer in use. So obsolescence comes from the word obsolete. Even though there is no overarching definition of planned obsolescence exists in the regular law, the term planned obsolescence is described as the intentional production of goods and services with short economic lives, stimulating consumers to repeat purchases too frequently. In a simple manner, if I may put it, it refers to any manufacturing strategy that prematurely ends the use of a product by a purchaser and thus requires a replacement purchase of the same or similar product. Wikipedia says in this manner, in economics and industrial design, planned obsolescence, also called built-in obsolescence or premature obsolescence, is a policy of planning or designing a product with an artificially limited useful life or a purposeful frail design so that it becomes obsolete after a certain predetermined period of time, upon which it decrementally functions or suddenly ceases to function or might be perceived as unfashionable. The rationale behind this strategy is to generate long-term sales volume by reducing the time between repeat purchases. It's usually referred to in business parlance as shortening the replacement cycle. It is the deliberate shortening of a lifespan of a product to force people to purchase functional replacements. Now, different terminology has been used in literature. It can be categorized into two broad categories. One is technological obsolescence or style or psychological obsolescence. Under the first category, technological obsolescence, producers deliberately design products with a shorter physical life than the industry is capable of producing under existing technological and cost conditions. Even though the cartridge could produce 100 or 200 more prints, but there is a built-in mechanism by which your printer will say that it is over and no more prints are available. Hence, you may have to go for a replacement, cartridge. So these are the mechanisms used. There are up to number, few of which has been referred to by Giri sir, and more will be referred to by Justice Surendra Mohan sir also, I'm sure. So what it does, it induces a process whereby producers artificially limit the durability of a product in order to stimulate repetitive consumption, or design in such a way that it functions for only a limited number of operations. Now, in the second category, it is nothing but what I said as perceived obsolescence. Where product lifespan reduction has occurred before products are placed on the market or afterwards is also very relevant. Now, I would go to the technological obsolescence can overlap with psychological obsolescence. Why? Because producers, that the persons who manufactures and markets which release technically updated products might persuade consumers who are vulnerable to status to buy the technically newer or better product, having iPhone 12 or iPhone, the latest version of iPhone or latest version of something, or a branded shirt or something with the new fashion in the market. If that can be equated, or social engineering could be done in such a manner that it is a status symbol, automatically the other things in the market which is having absolutely no defect or deficiencies will become obsolete or undesirable to the majority of the consumers. Now, one of the first attempts, I'll come to the history of obsolescence in a while, but it is in the early 1960s in the book, The Waste Makers. It has got a direct nexus with what do you call environment protection and ecological imbalance being created. The book's name itself is The Waste Makers. It is by Wayne Packard. He introduced three basic groups or types of obsolescence. Number one, obsolescence of desirability, obsolescence of function, and obsolescence of quality. Now, let us just briefly see what these categories are. This obsolescence of desirability discusses the development from a predominantly psychological, persuasive perspective. Its focus is on the question of how to make users purchase new goods without applying any technical barriers or introducing new technical features. The decision by General Motors, that is the first case, rightly put by Giri sir. Obsolescence, the finest and the first example starts from automobiles, wherein German Motors decided to have a model every year so that the old model could be phased out or rather become made obsolete, and new model and new what you call business could be generated. The decision by General Motors to update the design of its car at short intervals to outcome its main competitor, Ford Company, in the early 1920s is one of the finest reported cases of strategy aimed at obsolescence of desirability. Now, the second category, obsolescence of function. It could be understood to boost product sales by introducing or apparently introducing, need not necessarily introduce, allegedly introducing advanced technical features that would prompt users to replace a product with its successor. It is on the lighter vein, we can say that there is a radio model that is in the market with 2 bands. Then they come out with a model with 100 bands and say that, I'm talking about the STAs, and say that it's something good. Lifelong, you will hear only Vivek Bharati and Akashvani, and you don't need the other one. But some sort of desire is created that you'll go for the other model, and functionally no change, but the other model has become obsolete because of this choice that has been made or rather forced to be made by the consumer or the customer. The constant production of new generation of smartphones, as referred to by Giri sir during the introductory remarks, provides a modern day example of this type of obsolescence. Not that old models are bad, but we would decide to have the new model. Here, producers introduce new, more or less innovative features that tacitly or explicitly embody better or superior follow-up products. The obsolescence of desirability and the obsolescence of function relate to the voluntary end of product use rather than a forced end due to lack of durability. So it is in your mind, it is a mind game. Then the third category is obsolescence of quality. Here, a product eminent force, that is perspective, that is in the scenario, it is not the user's free choice to replace the product. The reason for replacement is that the product does not function or does not perform in a functionally efficient way, and likely repairs are no longer cost efficient. Finest thing is mobile itself. New model come, very new features are not able to be synced with that, so we'll have to go for a new model. As will be seen later, I said that in the later of my presentation, I'll be dealing specifically with these examples. So, while there is some understanding on what planned obsolescence entails, a legal definition is lacking, especially in India. France has come out, I shall come up with that. There is some sort of a definition, but in India, it is not defined. We'll have to strain it. I'll be doing it with 3 enactments. Number 1 is Sale of Goods Act, the other is Consumer Protection Act, and the other is the Competition Act. These 3 acts, if we go through that, we may be able to make some semblance out of it. And of course, the general law is there, general of contract is there, the civil remedies are there, tortious remedies, all those things are there. So what happens is that this creates a legal uncertainty, as it is not clear whether all these different nuances of planned or style obsolescence should be treated and addressed equally, or the legislature or legislator requires different approaches. Now let us see the historical context. It is said that those who don't learn from history are condemned to repeat it. So let us just have an overview of historical in a couple of minutes. Like this planned obsolescence concept can be traced back to the early 1870s in the United States in the context of disposable shirt collars. It did not rise to the prominence on the national level until the electric starter in the 1912 Cadillac Touring edition, which made all previous cars obsolete. So automobile industry, before that, of course, if you want to trace the history, you will find it in the disposable shirt collars. Now, planned obsolescence was also visible in industries other than the automobiles industry. The most notable example for the early years being light bulb, that is Phoebus cartel in 1921. Phoebus, as you might know, is a god of light, Greek god of light, prophecy, poetry, music, and healing, said to be the son of Zeus and Leto. In this case, the business agreed to intentionally limit the lifetime of light bulbs to 1,000 hours, with corporate resolutions to modify the bulb's filaments. So the bulb with the existing technology would have lasted longer, but by introducing some sort of technique, they limited the life to 1,000 hours so that you are compelled to purchase another one because this will be no longer functional. This could be, that is why it is known as Phoebus cartel in 1925. Another example is the strategy employed by DuPont to produce fast-wearing nylon stockings, which were easily torn or stretched, leading to a high number of sales throughout the 1950s and beyond. Now, let us not go that far. Let us see the future, the past, as far as we could remember. If we had a Hawaii slipper or a bathroom slipper, that would have lasted at least 2 to 3 years without any problem. Now, after the 4th or 5th month, the elasticity increases, the strap comes off. I mean, something all will happen. Almost with the shoes or whatever commodity you take. If you had a North Star shoe, I had it for 5 years, I believe. Nothing happened. I had to break it or rather tear it to get a new one because parents were refusing to get me a new one because there's nothing wrong with the existing shoes. There was no equation of having more than one pair of shoes then. If you have one, that's it. Until it goes out of use, you'll have to use it. Now, in the 20th century, where we faced 2 world wars, both global and national economies had come to a standstill, leading to the Great Depression. That is where I would like to make a point here in the sense like when we talk about a consumer, unless and until you have a manufacturer or a service provider, there is no existence for a consumer. So both has to coexist. It is just like the rent legislations, wherein if it's tenant oriented, unless and until there is a landlord and a premises to be rented out, there is no equation or relationship of a landlord and a tenant. Likewise, you cannot say that this is completely against the manufacturer or against the recipient or the purchaser, but an equilibrium has to be drawn. That is why during the 20th century, this was utilized by the state as a mechanism to revitalize the economy after the Great Depression. Planned obsolescence was seen as a way out of the 1929 economic crisis for the US government, which would collect more tax with increased transactions in the United States. Indeed, the Real Estate against Bernard Lenton, in his eminent article, where the concept of planned obsolescence was first defined, claimed that public and individual expenditures must be increased to create a more sustainable economic system by improving deficient demand through applying planned obsolescence strategies, with every commodity, including buildings and machinery, being declared obsolete after an allotted time by banning their subsequent use. So there will be circulation in the economy. Now, this was regarded as a way to provide a new reservoir from which to draw income for the operation of the government. This strategy was therefore employed to augment the volume of sales to boost the economy, as previously those goods had been built to last a lifetime. Then, apart from adjusting the product design, it was also necessary to change consumer consumption culture, like taking the washing of the clothes inside the house was a yeoman task, that you can use a bucket, you can use a bar soap, etc., and do the washing inside the house. But giving buckets, etc., free, they were able to get you in the house to wash clothes, etc. That's how they manipulate. It is even argued that every consumer could be manipulated by the culture industry to buy certain goods, even if they did not need them. Therefore, planned obsolescence was seen as a strategy of causing products to become obsolete before the end of their actual lifetime. In the 1950s, this was reinforced, both sides of the Atlantic. The throwaway society or the throwaway culture that came in for consumers to own something and a desire to have something a little newer, a little better, a little sooner than is necessary was inculcated. For using fashionable products has become an important indicator of human relationships, indicating some sort of status in society. This appertains directly to planned obsolescence by its very nature. Moreover, the throwaway culture was also adopted by producing disposable products such as batteries, cartridges, pens, razors, etc. Now, let us see the debates over the planned obsolescence. Early debates were characterized by economic and socio-political arguments. The topic began to gain momentum and attention when Packard's obsolescence publications were translated into non-English languages and sold abroad. In terms of focus of foreign debates, there was, however, not much difference from the US counterparts. Things started to change, and the planned obsolescence debate gained momentum with the rise of environmental movement in the 1970s. Till then, it was neglected. Whenever we say revitalizing the economy, having more production, etc., the waste perspective, the kind of e-waste and other waste, the impact on the environment was overlooked. That gained momentum. Nowadays, it is the most strong argument against planned obsolescence. Now, if you look at the European debates, in the recent debates, environmental concerns have overshadowed the other, unsustainable production and the utility of products. It has dominated the critical literature on planned obsolescence and respective policy discussions both at national and pan-European Union levels. Since the early 2000s, the European Union legislature has been intensifying its effort in passing environmental legislation that, in the view of European Union policymakers, has the potential to address the problem of planned obsolescence. Prominent examples include the Eco-Design Directive, the Energy Labeling Directive, the Waste Electrical and Electronic Equipment Directive, and the Waste Framework Directive, which all support sustainable production and consumption. At the European Union member state level, several initiatives have addressed the issue more directly. The success of these national efforts, however, differs considerably. In some member states, projects have not gone beyond mere policy debates. Examples can be found in Austria and Germany, both of which have been active in mandating pertinent studies and analysis, but thus far have failed to implement concrete rules or regulations. Germany is also among the member states that have attempted unsuccessfully to pass specific laws to support sustainable production. Legislative drafts found in these countries include a variety of mechanisms that range from prescribing mandatory minimum lifetimes for certain products to softer approaches such as broadening the use of lifespan labeling. The only successful example of the enactment of specific legislation on planned obsolescence you will find in France. That too in 2015. In 2015, that too driven by environmental concerns, the French legislature amended the French Consumer Code and introduced a specifically crafted penal provision on planned obsolescence. Article L213-4-1 reads as follows. Planned Obsolescence is defined as any measure with the intent to conceptually reduce the operating life of a good for economic considerations. And it is punishable with 2 years of imprisonment and a fine of economic union, the currency of 3 lakh euro, 3 lakh euro. In 2016, the regime was slightly updated and moved to Article L441-2, that is definition of planned obsolescence. The new definition of planned obsolescence is as follows. The practice of planned obsolescence is the prohibited use of techniques by which the person who places a product on the market aims to deliberately reduce the lifespan of the product to increase its replacement rate. The sanctions include a possible increase of the fine to a maximum of 5% of the average annual turnover, calculated based on the last 3 annual turnovers numbers known at the time of the offense. Despite these trends and efforts, legislators and other actors around the world have remained relatively passive when it comes to examining the full potential of warranty law in the obsolescence context. If warranty conditions and enforcement of warranty terms can be more strict and the life, etc., of the product would be either an express warranty or an implied warranty, and enforceability is assured, that could be one of the finest weapons against indiscriminate and unscrupulous and obsolescence. I may not make a statement that planned obsolescence is altogether bad or should be avoided, because that may not be, that would be just oversimplifying the entire scenario. Then, like I stated earlier, this is at times justified. For example, I told about that Bernard Lenton's call for shorter product lives, voiced in his controversial 1932 commentary, Ending the Depression Through Planned Obsolescence. So, planned obsolescence is seen as an engine for business growth, especially in the technology sector. Products are manufactured to become obsolete without which there is no growth. So it has to be balanced. Both will have to be, there should be a harmonious way of approach. But however, you won't find a phenomenon in the furniture market where repairability is quite high if things go away or products are upcycled to ensure that they last longer. So that brings us to the legal and social issues involved. I have identified 3, there will be more. Number 1, promotes culture of wastefulness, or it impacts the environment. I club both into one of my categories. That is, it promotes culture of wastefulness or insensitivity to the limited resources that the earth can provide. And wastefulness coupled with your scant regard for the environment or environmental issues. Number 2 would be, it restricts the consumer autonomy to keep products longer by hardwiring a self-destruct button in the products, or by restricting or even making it impossible to repair, or it become economically unviable to repair. Thirdly, and most importantly, though legally it may not sound that good, it develops social anxiety among individuals for not keeping up with the current trend. That might have a negative impact in any welfare state, because it will amount to discontent among the citizenry for no known reason for the governing polity. Now, let us see the legal landscape which we have discussed. France, like I said earlier, led the way on legislating against planned obsolescence. We saw that it is known as the Hammond Law in 2014. It sets the ambitious objectives of improving information, strengthening the cultural rights of consumers and the contractual rights of consumers, and supporting the sustainability and repairability of electronic products. It also extended the legal guarantee of conformity to specification by 2 years for electrical products. Then we have the Energy Transition Act of 2015. Then very recently, we have the Circular Economy Law of February 2020. Which imposed an obligation on producers, importers, or retailers of electrical and electronic products to communicate a repairability index for their products. It also prohibited any technique, including software, which makes it impossible for a manufacturer to repair or recondition an appliance without using its approved suppliers. We do have some legislations in these lines, not essentially regarding obsolescence or anything. If we see medical devices rules, the way which makes it imperative that disclosure to the nth degree regarding the product, and almost all medical devices are now equated as drugs, which comes under the stringent provisions of the Drugs and Cosmetics Act. So we are on the way, but we are not reached the area of comfort wherein we can call that we have a legal regime which will take care of these sort of unscrupulous manufacturers and service providers. Then finally, manufacturers must inform consumers of how long updates to the software provided at the time of purchase will remain compatible with normal use of the device. These provisions will be enforceable after enactment of specific decrees set to be published. Now, if we have Windows 9, 10, now 11 is coming. So many things are not compatible. You are compelled to purchase, and for that matter, if you purchase a new iPhone, adapter, the charging wire, etc., will have to be purchased separately. So it is just like you get the steering wheel, then you'll have to purchase the tire, everything, not the automobile as such. To that extent, it has gone. European Union consumer protection legislation may also apply under the Sale of Consumers Goods and Associated Guarantee Directive, that is Directive of 1999. European Union consumers are entitled to repair or replacement of goods which are not fit for purpose or not match the description given by the seller. Then we have the new Sale of Goods Directive in 2019, which will apply from 2022. US has no specific federal laws against planned obsolescence, but a number of cases have been brought alleging deceptive or unfair business practices or product liability claims for breach of warranty, which delivers similar outcomes to the consumers. It is more of a judge-made law there. Then we have the Federal Trade Commission, the federal agency responsible for consumer protection and competition issues in the US. They have also focused on managing consumer expectations around security updates for Internet of Things devices in recent years. It has recommended the manufacturers to consider telling users how long a device will receive security updates and when update support is ending. So the primary issue with this planned obsolescence is that you keep the consumer, the end purchaser, in the dark. He is not aware. This is something done behind his back. So one of the recommendations which I might place before this August Assembly would be that should it not be made punishable just like any other deception? Is it not deception? Then in Spain, consumer group FACUA made a complaint against Apple's Spanish subsidiary under Spain's. That I'm sure that during the discussion it will be coming up, and Apple had to dish out a large amount in a couple of the iPhone, etc. cases, which I shall refer to later. Now, all this has brought in a new movement. That movement's name is Right to Repair movement. That a consumer has got a right to repair and reuse something that he has purchased. It is not for the manufacturer to dictate. And you find that the warranty is void if you tamper with it or tinker with it, or if you go to unauthorized. These are all ways and means of enslaving you to their dictates. So the movement has come. In India, it is only growing. It has not got momentum. The right to repair and fair repair concepts began in the US with the auto industry. Massachusetts was the first state to pass a Motor Vehicle Owners' Right to Repair Act in 2012. The groundbreaking state legislation required every vehicle manufacturer to provide information to allow anyone to repair their vehicles. Now, I have a Ford Endeavor, which I call it as Fraud Endeavor. I'm sorry. If it has got any problem, I'll have to take it to that concerned, service center. And it is like admitting the vehicle to an ICU. They use the sensors, etc. And you don't find the conventional person with that waste cotton or that spanner which we see in Malayalam movie. Nothing like that. Small spanner or big spanner for that matter. Nothing. Everything is done and they alone can do. And they charge in such a manner that if I purchase it for 40 lakhs, I'll have to spend in the next 2 years around the same amount for the services, etc. without me knowing it. Inspired by this approach, the Digital Right to Repair Coalition was founded in 2013 to carry the same principles to consumer electronics like computers and cell phones. Then there is the Digital Right Repair Coalition. The Digital Right to Repair Coalition was incorporated in 2013 as a trade association. They chose to be a trade association rather than a charity because their goal is to lobby for repair-friendly legislation, standards, and regulations. Today, the coalition focuses on consumer electronics, including smartphones, computers, laptops, and tablets, but their attention goes beyond the standard focus of smartphones to address the repairability and reusability of other personal devices such as pacemakers or hearing aids. Now, however, the simplest way to recognize the right to self-repair is to incorporate it into the warranty law. One among the warranty conditions should be you got a right to repair, and the requisite information and techniques will have to be shared. So in sum, I would say regarding this aspect, warranty law would need to be expanded to include protection against actual defects and a separate duty of repairability. Now we'll come to the Indian scenario. Indian scenario, I'll examine only 3 statutes. Number 1, I would take you through the Sale of Goods Act. Let us just see the provisions quickly. Sale of Goods Act, couple of sections I would like to draw your attention. I'll just read the sections. That is, Prem, if it's available, you can put it on screen. Otherwise, it's okay. Sale of Goods Act, section 2(1) defines buyer. Buyer means a person who buys or agrees to buy goods. 2(5), 2 subclause 5 defines fault. Fault means wrongful act or default. 2(7) defines goods. Goods means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. Then we may directly come to section 12. Condition and warranty. 12(1). A stipulation in a contract of sale with reference to goods which are the subject thereof may be a condition or a warranty. A condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated. Whereas stipulation in a contract of sale is a condition or a warranty depends in each case on the construction of the contract. A stipulation may be a condition, though called a warranty in the contracts. I'm not going through the Contract Act because I'm sure that all of us are aware of the implied and express contract and how things can be promise, acceptance, etc. I'm not on that. So this has to be read along with the Contract Act. Now we'll come to section 16, mercantability. Implied conditions as to quality or fitness. Subject to the provisions of this Act and of any other law for the time being in force, there is no implied warranty or condition as to the quality or fitness for any particular purpose of goods under a contract of sale except as follows. Where the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are required. You have to drive the car, I'll have to use it lifelong, so as to show that the buyer relies on the seller's skill or judgment and the goods are of a description which it is in the course of the seller's business to supply, whether he is the manufacturer or producer or not. There is an implied condition that the good shall be reasonably fit for such purpose, provided that in the case of a contract for the sale of a specified article under its patent or other trade name, there is no implied condition as to its fitness for any particular purpose. Where goods are brought by description from a who deals in goods of that description, whether he is the manufacturer or producer or not, there is an implied condition that the goods shall be of merchantable quality, provided that, etc. An implied warranty or condition as to quality or fitness for a particular purpose may be annexed by the usage of trade. An express warranty or condition does not negate a warranty or condition, etc. Then section 58. Specific performance is possible. Unlike the Contract Act, wherein a breach of contract gives rise only for damages, here under section 58, specific performance, subject to the provisions of chapter 2 of the Specific Relief Act 1877, in any suit for breach of contract to deliver specific or ascertain goods, and court may, if it thinks fit on the application of the plaintiff by its decree, direct that the contract shall be performed specifically without giving the defendant the option of retaining the goods on payment of damages. The decree may be unconditional or upon such terms and conditions as to damages, payment of the price or otherwise as the court may deem just, and the application of the plaintiff may be made at any time before the decree. Finally, two more sections, that is section 59, remedy for breach of warranty. Where there is a breach of warranty by the seller, or where the buyer elects or is compelled to treat any breach of a condition on the part of the seller as a breach of warranty, the buyer is not by reason only of such breach of warranty entitled to reject the goods, but he may set up against the seller the breach of warranty in diminution or extinction of the price, or sue the seller for damages for breach of warranty. The fact that a buyer has set up breach of warranty in diminution or extinction of the price does not prevent him from suing for the same breach of warranty if he has suffered other damages. 62 may also be seen, exclusion of implied terms and conditions. Where any right, duty, or liability would arise under a contract of sale by implication of law, it may be negative or varied by express agreement or by the course of dealing between the parties, or by usage, if the usage is such as to bind both parties to the contract. So, Sale of Goods Act is one act with which we may have to deal if we are talking about taking action pertaining to planned obsolescence. Then the next enactment which I would like to touch upon is Consumer Protection Act. I'm sure that with the Surendra Mohan sir here, I'll be it'll be too much for me to say too much on that, but still the basics at least I may be permitted, in the sense like the internationally recognized consumer rights. The United Nations guidelines for consumer protection include the right to safety, the right to be informed, the right to choose, the right to be heard, the right to satisfaction of basic needs, the right to redress, the right to consumer education, all this. Now, coming back to the act, the new act, 2019 act, few provisions which have to be looked into are Section 2, subclause 9 defines consumer rights. Consumer rights include the right to be protected against the marketing of goods, products, or services which are hazardous to life property, the right to be informed about the quality, quantity, potency, purity, standard, and price of goods, products, of services, as the case may be, so as to protect the consumer against unfair trade practices, the right to be assured, whether possible, access to variety of goods, products, or services at competitive prices, the right to be heard and to be assured that consumers' interests will be received due consideration, the right to seek redressal against unfair trade practice or restrictive trade practices or unscrupulous exploitation of consumers, and the right to consumer awareness. Then I would also, let us see the definition of complaint. Section 2(6). Complaint means any allegation in writing made by a complainant for obtaining any relief provided by or under this act that an unfair contract or unfair trade practice or a restrictive trade practice has been adopted by any trader or seller or service provider. There are others, and I'll come to the last one, that is 2(6) subclause 7. A claim for product liability action lies against the product manufacturer, product seller, or product service provider, as the case may be. So we have unfair trade practice and restrictive trade practice coming in the form of a complaint. It is embedded into consumer rights as defined under 2(9). Then 2(10), defect. Defect means any fault, imperfection, or shortcoming in the quality, quantity, potency, purity, or standard which is required to be maintained by or under any law for the time being in force, or under any contract express or implied, or as is claimed by the trader in any manner whatsoever in relation to any goods or products, and the expression defective shall be construed accordingly. Then deficiency, of course, means any fault, imperfection, shortcoming, or inadequacy in the quality, nature, and manner of performance. Then 2(12) defines design. In relation to a product means the intended or known physical and material characteristics of such product, and includes any intended or known formulation or content of such product and the usual result of the intended manufacturing or other process used to produce such product. Then 2 subclause 20 is express warranty. Express warranty is defined as any material statement, affirmation of fact, promise or description relating to a product or service warranting that it conforms to such material statement, affirmation, promise or description, and includes any sample or model of a product warranting that the whole of such product conforms to such sample or model. Then 221 is goods. Goods means every kind of movable property and includes food, etc. Earlier it was goods as defined under the Sale of Goods Act. Now it's every property is brought in. Then 222 harm here defined. 223 injury. Then 224 manufacturer. We shall come to when we deal with Competition Act. Then 228 is misleading advertisement. Subclause 33 a product is defined. And 34 product liability. 36 is product manufacturer. 37 is product seller. 38 is product service provider. 45 is trader. That is in some importance. Trader in relation to any goods means a person who sells or distributes any goods for sale and includes the manufacturer thereof, and where such goods are sold or distributed in packaged form includes the packer thereof. Now, two important definitions are 241 restrictive trade practice and 2 subclause 46 unfair contract. Restrictive trade practice is 2 subclause 41. A trade practice which tends to bring about manipulation of price or its conditions of delivery or to affect flow of supplies in the market relating to goods or services in such a manner as to impose on the consumers unjustified costs or restriction and shall include A, B, C, D, etc. So this will amount to unfair restrictive trade practice as defined under 241, and in unfair trade practice subclause 2 subclause 47 247 subclause 4, 5, 6 and 7 assumes importance. 4 says permitting the sale or supply of goods intended to be used or are of a kind likely to be used by consumers knowing or having reason to believe that the goods do not comply with the standards specified by the competent authority relating to performance, composition, contents, design, construction, finishing or packaging as are necessary to prevent or reduce the risk of injury to the person using the goods. Subclause 5. Permitting the hoarding or destruction of goods or refusal to sell the goods or to make them available for sale or to provide any service. If such hoarding or destruction or refusal raises or tends to raise or is intended to raise the cost of those of or other similar goods or services. So obsolescence is fairly covered because you shut the chain of supply of spare parts, etc., so that the consumer is constrained to make a purchase expending more money. Then subclause 7, 4, 5, 6 also. Manufacturing of spurious goods or offering such goods for sale or adopting deceptive practices in the provision of services. Then 8, subclause 8, refusing after selling goods or rendering services to take back or withdraw defective goods or to withdraw or discontinue deficient service and to refund the consideration thereof if paid within the stipulated period in the bill or cash memo or receipt or in the absence of such stipulation within a period of 30 days. So all this could be read together, and we'll just see two provisions in Consumer Protection Act, which is section 18 and 39. 18 is powers and functions of central authority. Unlike the earlier act, a new authority is constituted, which is known as the Central Consumer Protection Authority, a very powerful authority. 18 says the central authority shall protect, promote, and enforce the rights of consumers as a class and prevent violation of consumer rights under this act. Consumer rights we've seen, it includes this as well. Specifically in subclause B, prevent unfair trade practices and ensure that no person engages himself in unfair trade practices. So that apart, we can also see 19, power of central authority to refer matters for investigation or to other regulator. 20, power of central authority to recall goods, power of central authority to issue directions, etc. Very powerful authority. Search and seizure, etc. is provided. Now we'll come directly to 39. 39 is the provision procedure, findings of the district commission, a pari-materia provision for state commission and national commission also. There, I request the attention to 39(1)(g), where the district commission is satisfied that the goods complained against suffer from any of the defects specified in the complaint, or that any of the allegations contained in the complaint about the services or unfair trade practices or claims for compensation under product liability are proved, it shall issue an order to the opposite party directing him to do one or more of the ABCDEFG to discontinue the unfair trade practice or restrictive trade practice and not to repeat them. Powerful, competent, and can do that. So, as a consumer, you can. But the issue is that you should come under the definition of a consumer. Now, let us see the last enactment which I wanted to touch upon today. That is the, and for that matter, I'll just refer to two decisions. That is 2016 Volume 3 CPJ 426 by the National Commission. It's a very interesting decision wherein the right to get spare parts, etc., was held to be a inalienable consumer right by the National Commission. That is Messrs. Honda Sale Cars India Limited versus Rohit Jain and another. Revision petition number 446 of 2013, rendered on 31st March 2016 and reported in Volume 3, 2016 Consumer Protection Journal 426, National Commission. Then we have Samsher Kataria versus Honda Sale Cars India Limited and others. That is by the Competition Commission of India. That we'll come to in the next few minutes. Now, the next is the competition law. That is the Competition Act. The preamble itself says to act to provide, keeping in view the economic development of the country, to protect the interests of the consumers. Section 2F defines consumer. Here it is a more wider definition, because in the Consumer Protection Act, for resale or for commercial purpose is excluded, whereas the definition under 2 subclause F of the Competition Act says that whether such purchase of goods is for resale or for any commercial purpose or for personal use, it is included. Then comes goods. Goods imported in India is also included. So it could be juxtaposed with the provision under Section 221 of the Consumer Protection Act. Then practice, price, service are all defined, and trade means any trade, business, etc. Then Section 3 is more important. Anti-competitive agreements, wherein any agreement amongst enterprises or persons at different stages or levels of the production chain in different markets in respect of production, supply, distribution, storage, sale, or price of goods are condemned. And specifically, you will find in 3.5, nothing contained in section shall restrict. That's the only thing. Intellectual property rights are protected and preserved. Then section 4 is important because abuse of dominant position. No enterprise or group shall abuse its dominant position. There shall be an abuse of dominant position under subsection 1 if an enterprise or a group directly or indirectly imposes unfair or discriminatory 1, 2, 3, 4. And specifically, I would say 19.4, the Commission shall, with while inquiry whether an enterprise enjoys a dominant position or not, under section 4, have due regard to all or any of the following factors, namely vertical integration of the enterprises or sale or service network of such enterprises, dependence of consumers on the enterprise, monopoly or dominant position whether acquired as a result of any statute or by virtue of being a government company or a public sector undertaking or otherwise. Then there is extraterritoriality in the sense like the Information Technology Act, section 32, takes care of acts taking place outside India but having an effect on competition in India. Then interim orders can be granted under section 33. Consumer Protection Act also, section 38, subclause 8, gives power for provision for granting interim orders. Then, so these are the 3 enactments which I could find in the Indian context. So to conclude on this topic, I've just keep some placed some suggestions for the contemplation and deliberation of this August assembly. Number one would be to counter this practice, we can insist on pre-contractual information in enforcement of pre-contractual information a mandate, one. Then legal guarantee also increases. Legislative powers may extend the Spanish legal two-year guarantee period. So there will be a legal guarantee. Then increase of spare parts availability. Then we can follow the French model. And before I come to the concluding remarks on what all we can do or what all things are available, I just also would like to share with you some thoughts that what are our responsibilities? Are we just to complain or just meet and debate or deliberate over that? Do we not have any responsibility? Number one is refuse to buy. As a consumer body, we can, let us not get swayed by the newest trends. Saying is very easy than practice, I know, but still, advertising can be beautiful, but our environment is even more beautiful. Think twice before buying anything and remember that there is already too much waste on this planet. Also refuse proprietary accessories in order to be able to use them with future products. Then reduce your buying frequency by keeping your things as long as possible. Your phone battery might be getting weaker, your apps might work slower, but it still works. So keep it until you really can't repair it. Then reuse. Repair whenever possible or find a new use for your items. Also, instead of always buying new unused items, buy someone else used or upcycled items. This helps to ensure that items are being used and reused for more of their useful life. Then recycle. Once it becomes obsolete, which is inevitable, be sure to recycle your items at a right location. You might find e-waste recycling information in city websites, etc. Then redeem. Always redeem your points before you deserve it, and then rebuy. Buy items made from recycled materials. This helps to close the loop on sustainability. And I just conclude the my presentation on this topic by just placing few things how we can prevent or how it can be dealt with. Number one is prevent monopolies, ensure competition, prevent cartelization. Once there is competition, and if the consumer is educated enough, no manufacturer would like to run the risk of playing these sort of games because they will be unfavorably seen in the market and they'll be driven out of the market, which nobody wants. Number one. Number two, recognize the right of repair as a legally enforceable right by legislation or proactive interpretation of the existing laws, if it is possible to. These are my stray thoughts, which I thought I will share with you. So first is prevent monopolies, ensure competition, then there will be self-regulation. Number two is recognize the right of repair as a legally enforceable right. Then we require legislative action by either having specific enactments or studied amendments of the existing law. Not a knee-jerk reaction like we see nowadays when we have a legislation coming up and then it being amended, but the existing legislation can be amended. Then the laws with which we can think about is unfair competition or antitrust or unfair commercial practices laws, environment laws, consumer protection laws, all can be made more effective. Then what can the other, like the judiciary can do? Proactive interpretation, for which I again reiterate the often quoted decision of Justice K.T. Thomas, that is Messrs. SIL Imports USA versus Messrs. Exim 8 Silk Exports Bangalore, AER 1999, Supreme Court 1609, wherein it was a case, I'm sure that all of you would have at least gone through that, in the sense like it was a case wherein notice was sent through fax in a 138 case, and the magistrate level till the Supreme Court level, it was dismissed, saying that it ought to be under registered post acknowledgement due. Then the apex court asked, where is it written in the statute that it should be by receipt? It's only intimation. If a new technology comes, why can't you utilize that? So an interpretative process, that is where Justice, speaking through Justice K.T. Thomas, the apex court said, statutory interpretation should give allowances for any relevant changes that have occurred since the act's passing in law, social conditions, technology, meaning of the words, and other matters. And the use and thus use the interpretative process to the fullest extent permissible by the enactment. So I think the proactive judiciary can also do a great deal in this aspect. Then we'll have to strengthen the consumer movement. How can it be done? Warranty laws has to be made stronger. Definition of express and implied warranty. Now the issue is that we do not have a clear statutory warranty period. It is a case-by-case approach. And even in that National Commission ruling, I said it was an approach, and in a later decision, it was distinguished also to a certain extent. Let us move towards incorporating the right to self-repair or cross-border right to repair or self-repair as part of warranty law and part of the consumer movement. Then on account of the cross-border sales perspective, we should also move towards a uniform international warranty law, just like we have environmental laws are in tune with the international law, Consumer Protection Act, Information Technology Act, and the new generation laws are all in tune with the international requirements. Let us also have something like that. And then finally, I would also say that why, like I said earlier, why can't we make this an offense punishable like any other deception? So I would conclude by just stating this is a subject which requires a holistic approach. It has to, all the stakeholders will have to be taken into confidence, and it is not one-sided. We just cannot be overawed by condemning by the environmental issues alone, or what do you call the consumer rights alone, or for that matter, a capitalist society should not exist wherein the manufacturer is exploiting, etc. But peaceful coexistence may be able to be ensured by a proactive and a balanced approach on this one. Thank you for your patience, and Prem, with your permission, may I request Justice Surendra Mohan sir to render the concluding remarks on this subject so that we'll have a completeness of the subject.
Thank you very much.
Yes, sir, you are audible. You are audible, sir.
Okay. Thank you very much, Shyam. You have made a very comprehensive and exhaustive presentation of the subject, planned obsolescence and consumer rights. It is a very important aspect of consumer protection, and you have addressed it very well. See, the consumers as a class form the most exploited class or section of society in all countries. See, we are constantly bearing the burden of the fuel prices that are going on increasing. We do not know what is the reason for the increase. Today also the prices of petrol and diesel have gone up, and the consumer is left to silently suffer and bear the burden. That is the biggest problem as far as consumers are concerned. They are not organized, they are dissipated, they are scattered in the society, and they have no organization to mount an agitation against unreasonable price hike, or even if it is unreasonable. Now, the new Consumer Protection Act 2019 envisages the establishing of a consumer protection authority, the Central Consumer Protection Authority. And the Central Consumer Protection Authority has got powers to regulate matters relating to violation of consumers, violation of rights of consumers, to unfair trade practices, false or misleading advertisements which are prejudicial to the interests of the public and consumers, and to promote, protect, and enforce the rights of the consumers as a class. The Central Consumer Protection Authority is armed with powers under the Act to investigate, prosecute, and punish the wrongdoers. The authority has got the powers to take help of other regulatory bodies for the discharge of its functions. But unfortunately, the Chapter 3 of the Act, which contains these provisions, have not been brought into force, though all the other portions of the Act have been brought into force. Thereby, the prospect of a central consumer protection authority wielding powers and protecting the rights of the consumers remain even now a distant dream. We have to wait and see when this chapter and the provisions contained therein would be brought into force. We'll also have to wait and see what would be the constitution of the Central Consumer Protection Authority and how it is going to be going to function to give better enforcement to the rights of the consumers. That is one aspect. So this planned obsolescence, when the manufacturer, of course, we have to recognize the fact that the manufacturer also has to survive after having borne the burden of a capital expenditure to establish this manufacturing unit and to see that the products are brought out. And he has got an establishment to support. He has got laborers who are working and the products come in a steady flow, which are required to be marketed, and unless the consumers purchase those goods, then all his activity will come to a standstill. It is for that purpose that new models are brought in or introduced to the market. And every new model will announce a lot of new features with the object of attracting the consumers to discard their old models and to opt for the purchase of a new model. But at the same time, there would be a lot of consumers who would not be willing to let go of the model that they were having for the reason that it was perfectly in order or working perfectly, and that or that they are not in a position to shell out additional cash for the purpose of purchase of a new one. Therefore, there must be a harmonious balancing of both these interests. It is certainly true that we should insist no exploitation of the consumers by such planned obsolescence. Now, we are all familiar with the Toyota Qualis vehicle that is no longer to be seen, though I am aware of a number of people who are still using the vehicle without any problems. But then the lack of availability of spare parts, lack of provisions to have the vehicle repaired, all these things would put pressure on the consumer to discard the vehicle even though it is in perfect running condition and to go for a new model. It is this kind of a pressure that is exerted on the consumer that requires to be regulated and curbed so as to ensure that the consumer is not exploited. In most cases, the consumer is left with no option but to succumb to the exploitation that is planned by the manufacturer and put into effect. Now, that a reference was made to the iPhone, which has been bringing out models year after year. Now people are eagerly waiting for the next model to come, which is trotted to offer a lot more other facilities. However, the fact remains that most of the consumers use their mobile phones only for the making of calls. and sometimes for sending their emails. The other features that each of these instruments boast of remain unused in the instrument. At the same time, the consumer would have paid for those facilities. Also because the product is priced that way. It is a trend among the manufacturers to ensure that the consumer comes back for a later model to replace the model that he was using, because only such a consumer would be able to bring any profit to the manufacturer. In order to ensure that, it has been the trend to make products that are less durable, so that within a few years, the consumer would have to return to the manufacturer for purchasing a new one. If you look at the way in which the ready-made clothes are being made, you will find that most of the clothes become worn out after about 10 or 15 washes or 25 washes. And when I inquired about it, the explanation that I got was that the manufacturers do this to ensure that the consumers go in for a replacement. It is true that it is necessary to induce the consumers to replace the articles that they are using, but at the same time, we find that when the quality of the products are diminishing, the prices of the articles are increasing exponentially. We find now, if we look at the apparel industry, a shirt costing 3,000 rupees, but then in spite of its price, it will not last more than a year. So that puts the consumer at a great disadvantage, bringing us to the question as to whether the consumer should not be conferred with a right to question the price that is charged for an article. What is the role of the consumer, or should the consumer be given a role in determining the price of a particular product? If we want the manufacturer to generate his profits, but how much? We know that the cost of manufacture of a shirt would be at the most say 1,000 rupees, but when they sell it for 3,000 rupees, the profit goes manifold. The consumer cannot have any objection to 15% or 10 or 15% or 25% or 30% profit being taken away by the manufacturer. But then when the profit is 300% or 400%, you are left wondering, is it justifiable? And there is no mechanism, there is no machinery by which we are able to question this, because the manufacturer would say that we are not forcing anyone to buy our products. It is the consumer's individual decision to purchase our products. So that again is a fallout of the planned obsolescence that impacts the rights of the consumers. And we as consumers also do not have any information regarding the technical specifications of the article that we are purchasing. We will not be able to assess or understand whether a particular car would last for the next 5 years. Normally, it is our mindset to wish that when we purchase a car, it would last for at least 5 years, so that we are disappointed if the car develops problems within even that span of expectation. See, another area that I would like to refer to is the area of food. We have, after our economy has opened up, we have a number of multinational companies flooding our markets with products, what we generally call the FMCGs, the fast-moving consumer goods. See, the issue of the Hindu newspaper of 6th June, that is a few days back, carried an article on the products that are manufactured and marketed by the Switzerland-based multinational company Nestle. And starting from 2-minute noodles, the company sells a wide range of food products that target our children and youngsters. And according to the article, a majority of the food and drink products from Nestle could not be considered healthy. The article reports the spokesman of the company as saying that, I quote, looking at the global portfolio as a whole, less than 30% would not meet stringent external healthfulness standards, mostly representing indulgent products which are acceptable in moderation as part of healthy, balanced and enjoyable diet, the spokesman is reported to have said. Therefore, they admit that their food products are at best suitable for use in moderation along with a balanced diet for enjoyable purposes. And having said this, it is also reported that the company is proposing to start an intensive advertising campaign to assure and retain the consumers. So that the advertising campaign is going to be aimed at assuring and retaining the consumers. There is absolutely no intention to improve the quality or improve the healthfulness of the products. Therefore, see, we are left wondering whether this is not again an instance of planned obsolescence, where especially our children, they would want the 2-minute noodles, they would want the other products like, see, they manufacture a lot of things like the Nescafe is there, Nan Pro infant formula, chocolates like Kit Kat, Munch, Polo, milk products like yogurt, slim milk, and a wide range of products. And these products, they accept that they are not, 30% of their products are not healthy at all. And so we have a situation where the consumers do not have what is called safe food available in our market. The multinational companies that come into it with their, on the strength of their brand name, which has got a long standing, they impose on the consumers products that are attractively packaged and advertised intensively with the object of luring the consumers towards those products. Well, this is also one aspect of planned obsolescence on which we would have to think of imposing some restriction or regulation so that the rights of the consumers could be protected. And fixing of price, I believe, is one aspect on which the consumers should have a right to question. That again, I do not know whether it would come within the definition of a consumer dispute, where the consumer has not purchased the article, or even if he has purchased the article, we'll have to wait and see. Now, the 2019 Act has only just come into operation. The provisions will have to crystallize in the crucible of the society, that litigations on various aspects of the law would have to come, and crucial concepts will have to be interpreted and understood in the proper perspective. We'll wait for that. Anyway, it has been a wonderful evening listening to Shyam, and thank you for the opportunity for airing my views on this aspect. Thank you.
Thank you. Thank you, sir. Ramkumar, sir.
A very vibrant and useful subject. In fact, when I saw planned obsolescence and consumer rights, I initially thought that Shyam was targeting the legislature in coming out with the new law, which he himself had once said that it is full of inadequacies and this thing. So I thought that he is targeting on the legislature.
I
Luckily,
saved
he's
it for
not.
another occasion, sir.
Luckily, you are not that. In fact, both mindsets are good according to me. The brighter side of one aspect and the darker side of the other aspect also. Planned obsolescence, when what Shyam had in mind, I got an idea only when Mr. Giri gave some introductory remarks. See, it may be a deliberate marketing strategy with a view to exploit the curiosity or the weakness of the consumer. And on the one hand, we see the avaricious manufacturer indulging in that. But on the other hand, there are also improved versions. The products of research and analysis, research and development of every manufacturer should not go waste. If as a matter of fact, they come out with really improved versions with really good good properties. Nothing wrong in doing that. But only thing is, we had a time when we were more were more stressed on durability. Now it has from that planned durability concerns, we have shifted to a sort of disposable or what should I say, disposable or throwaway consumerism. That also can give rise to lot of product debris also. In fact, once a lifetime accomplishment, manufacturers had to strain much to disabuse the owners of their sentimental attachment to the products and come out with new improved versions. Whether it is for good or bad, the posterity will decide. The Chinese must have been the greatest violators for coming out with this flimsy and products. But anyway, it's a good articulation, and you have done it in your own inimitable style, Mr. Shyam. And as rightly anticipated, the subject became complete with the articulation by Justice Surendra Mohan. Thank you. Giri also did a beautiful introduction. Thank you all.
Thank you, sir. Justice Ramushan, sir.
Yes, really, as Ramkumar has said, when I saw the topic, even I was not understood. I could not understand what is intended by that. But when I heard Giri, I understood that what was behind it, and how the consumerism of the people is being exploited by the manufacturers by introducing new products. See, one thing is there, as Ramkumar sir has said, it is always, choice is yours. Why do you go and purchase when new versions comes? Because I had an occasion to interact with MC Mehta, the founder of environmental jurisprudence, when I was attending a seminar where he was also addressing. He was also saying about the same thing. Because every year new products of electronic goods are coming up. Instead of that, because as Ramkumar has said, when in our, we can't say that we are living in both time now. Because when we are young, our parents will purchase some article which will be durable for a longer period from your 5th standard to SLC or even college days. When a pen is purchased, you will not be replacing it every day, a pen. That will be reusable by adopting some method, and you will have to only replace certain articles like nib or something like that, and you are using it for a longer period. That was the intention of the consumer at that time, and also the concept of the manufacturers were also to provide a long durable healthy articles. But now, as Ramkumar has said, it has, because similarly ballpoint pens, we were never replacing it with a new pen, but you are replacing it with a refill. But now that concept has gone. Even people were not interested in, see, even when I asked the office, why can't you purchase the refills and keep it so that we can use the pen for a longer period? Then they no, sir, you will have to pay more for the refill than the pen. So it is always better to go for a profitable one that you can purchase pen. Thereby you are creating a waste, and nobody is there to collect those waste and dispose it in a way, the environment friendly manner, but that will be disposed of also. So these are all the hurdles, and then only one question will be possible: go by Gandhian principle, quit India process, or the boycott the foreign goods. That is the only thing possible. When you are not suitable for your need, or if you are not suitable according to your wish, don't buy it. That is one method by which you can deprecate or dissuade the manufacturers using this indigenous method of providing so many things. MC Mehta was suggesting one aspect which I also felt that will not be implemented, because as far as electronic goods are concerned, instead of going for different type of new versions, why can't a provision be made to incorporate those new versions in the existing system itself? Because technology can be used in that way, so that your own old system can be utilized for that, by adding some versions also for this, updating your old version of the instrument, so that you can use the same thing, because it is not you are throwing it away because it is not usable or it is not helpful. But when it comes to the usability in turn with the new version that has been provided, it is not suitable. When that comes, the system itself says, no, your system will not accept it. So instead of that, why can't a provision be made? Or as the Shyam has said, there must be a clause in the purchase, the bill or something, contract itself, to replace it or update it with the existing instrument that is being used for that purpose. So if such a provision is made, to some extent, I think that use and throw the concept can be avoided, and maximum utility can be utilized with the existing system itself. Thereby, you can also reduce the waste, that too very dangerous waste. Even some of the provision says some of the components that has been used in this e-waste are having you will have to destroy in such a way that using the atomic this thing procedure to be done for that purpose, because some components that has been used are also having such a radioactivity capacity. So these are all the areas, and also one of the provisions in the e-waste also provides for extended producers liability. I do not know, because I am asking about the Pollution Control Board chairman now, whether any guideline has been given, though Rule 5 of the rule says there are certain responsibilities on the producer. And even the awareness program, awareness of the things that has been done, what are all the responsibilities of the manufacturer, what are all the duties of the producer, what are all the duties of the dealer, etc., will have to be explained to the purchaser also, that such a responsibility is there. And also they must also provide a mechanism by which this can be collected back and it can be recycled or disposed in a scientific manner. Provisions are there. As far as India is concerned, prior to 2016 e-waste management rules, you are governed by 2011 rules. All rules are there, but whenever this extended producer liability comes, always there is a lag on the part of the government also to implement it, because they will be having some discussions with the manufacturer as to how this can be implemented without affecting the right of the manufacturer. They are not concerned about how it can be implemented for the benefit of the consumer or the public. how it can be done in an environment friendly manner also. These are all the areas where I do not know any, because certain provisions of the e-waste management rule says Central Pollution Control Board have to give certain guideline as to how, when the violation comes, the punishment will have to be provided, etc. I do not know whether those things are, because EP Act says any offense, any violation of any of the rules enacted under the rules will come under section 15. But whether how far, what is the nature of punishment, how this will have to be proved, all those things are all there. And also some people will say, when you go to the purchase of mobile phone, they will say, sir, you will be giving one year warranty. And if you want extended warranty for 2 more years, you will have to pay so much amount, so much percentage. Then when after getting those amounts, if you say some mistake or some defect comes, if you go there, they will say, sir, that the manufacturer stopped the manufacture of this type. You won't get the spare parts for those things. So repair is very difficult. How will you enforce? That is one area where how far it can be enforced. These are all not known to the consumer, and they were compelled to give it back. And also there is a responsibility on the dealer to, when you are doing it, you will have to get back the old one, and when you are purchasing a new one. But if you go to the shop, they will say, sir, we will give you 500 rupees discount or 1000 rupees. If you bargain for that, they will say 1000 rupees. Then allowed to keep the article with you only, because it become a waste in your house. They won't take it back, and then they won't do it. And also I find one of the provisions in the e-waste management rules, there is a provision they can demand for a deposit of taking back. And at the time when the end life is over, when it is returned, they will have to receive the article and repay the deposit with interest at the prevailing rate. I do not know how many dealers are doing it. How many of them, even I was not aware of it. When I saw these rules, I came to know that such a provision is there. They are not insisting for such a deposit. There is a scheme provided under the rules itself that they will have to have a, what I call that name of this thing is deposit refund scheme. So you can fix an amount for that purpose as a deposit with them. When the end life is over, when you go for purchase a new one, they will have to take back the old one. Not only that, they will have to repay the deposit with the interest. I do not know whether that is being adopted or that is being practiced at all. So these are all the areas where the consumer must also have some awareness about their rights which are provided under the statute itself. A lack of knowledge of those things, even a person like me, only when I came to this field, when I had the opportunity to go through the rules, I am understanding this. I do not know how many of the lawyers may be knowing about these things. Even the persons dealing with the consumer protection may not be knowing about these rules which have been framed under the Environment Protection Act. So these are all the areas where people must have an awareness about it. And it is a responsibility of the manufacturers themselves to do it, because Rule 5 imposes that responsibility on them. So these are all the areas where it is for the lawyer community to come with an awareness program to the people about their right, because it is not that law is not provided for your protection also. But only thing is people are not aware of it. When the new version comes, the younger generation thing, why throw off the old one and get a new one. That is the mindset of the people also now, without knowing about the danger that is being perpetrated by them for the environment, which affect their life itself. So
Correct,
these are
correct.
no, these are all the areas where I think that greater awareness must be imparted. And also, to some extent, we will have to restrain ourselves from going for such new products and insist for a new version. New version will not be incorporated in our old system itself, so that the old system can be used for a longer period as we were doing it earlier. That can be done. That is the only thing I can, as far as the price and other things are concerned, I do not know, because the competition authority can deal with those all things, I think, to some extent. I do not know how the MRP is fixed, what is the role or what is the mechanism that has been adopted for the purpose of fixing the MRP, etc. So all those things. And Food Safety Act I don't think that it is a more dangerous thing. As I also read the article in the head new. When I came to know about that, I am shocked to say that 30% of the articles that has been produced by Nestle as the Maggi noodles or something like that is unfit for human consumption. And it is not healthy for the younger generation also. But in spite of that, sales are going up, and they are getting more profit and they are getting enriched, and at the cost of the health of the people. And there is no mechanism, even knowing these articles, how many prosecutions have been launched against those persons for selling such inferior quality articles. These are all the areas where regulators, as one of the Supreme Court decisions has said, see, non-enacting a law may be tolerated, but non-implementation of the existing laws cannot be tolerated. That is what is going on now. So thank you very much for a good eye-opener subject. And really, it's an area where people must know about their rights, and also some enactment or some provisions will have to be made by the government by enacting suitable provisions protecting the interests of the consumers also on these aspects. Thank you very much.
Thank you, Ramashan sir.
This use and throw habit is entering the matrimonial field also.
No, everywhere is extended.
There was a recent article about honey that is sold in our
Yes.
market, where
Cashew nut also.
reputed manufacturers like Dabur, Hamdard, Patanjali, all these people are selling some chemical product in the name of honey. And
qualities.
Jaggery water.
Not jaggery. They are importing a particular
From China, some articles. Some China.
China, they are, and now after that, now our government has now banned import of that substance. But I'm sure that it would be coming in clandestinely without the knowledge of the authorities. That is what banning. So that there are so many areas in which this is going on.
Now let us hear.
Why the Food Safety Commissioner take action against those people? I do not know why this is not being done.
Even though the honey scandal had come, no single prosecution was launched.
They are interested only in the safety of their food.
I think Justice Giri has gone.
Okay.
So,
I think so. Giri sir, are you there?
I think he has just,
Just
lost the connection. Lost the connection, I believe. We'll go to Vijay, then Prem.
Well, yeah, Shyam very beautifully explained. When we had this meeting, Shyam did talk about planned obsolescence. Even I am unable to pronounce it right unless I read it more than once. I didn't understand what he said initially. He was very excited, but I didn't understand what the topic was about. Then there was this Zoom meeting affairs in the Zoom meeting. But as the moment you started, the first thing that struck me was what happens to the e-waste, because that is a major contributor for pollution, because that is a impact which this, if there is a law with regard to controlling this particular issue, I think the e-waste could be controlled in a big way. I think Justice Ramakrishnan sir has put all the issues for consideration, because it's a major issue. And there is one particular, I think all the world's waste is taken to one particular place and it is being reused or reassembled there. There is a liability of the manufacturer to collect it and send it back to the place out of India. So I think it is being sent to some Norway or some place. I'm not very sure. But that was what which initially struck me. And as regards to food adulteration, one fundamental thing when people, the commoner, the village, rustic, rural villager, when they talk is, how is it that milk is available for so many people when the cows are not there? So that's a very pertinent question which they ask. And the ghee that is produced in the market is a doubtful ghee. I'm not saying all are like that, but because there is no sufficient cows or buffaloes to generate that kind of food for all the people. In fact, to the gods also, because you do abhishekams and all. We are not sure whether that's the right milk that is being poured on the Lord. It's always a mystery, but then we have to trust the system and take it as milk and honey and all these things, because we can't keep on doubting at every step. Thank you, Shyam.
Alan, not that I think earlier, when the earlier Food Adulteration Act was there, a lot of prosecutions used to come. But now, after the new act came, I think the number of prosecutions are less. No prosecution at all. No prosecution at all now. And even I think, I do not know whether the regulators have been appointed under the act.
It's a food-friendly act, maybe.
Which friendly act?
Thank you, sir. You have addressed it beautifully.
Thank you. And for that matter, the Consumer Protection Act, the definition of goods, just like Justice Surendra Mohan sir said, takes in food as well. Now, earlier it was not good. Now, food is also taken into. So, an additional fora, and especially going by Section 100 of the new Consumer Protection Act, which is in pari materia provision of Section 3 earlier, it is an addition to and not in derogation of any other law. So, one more fora has come in to actively involved in this food adulteration thing. K.V.Giri also.
Excellent articulation. Only reminds me from the time we used to stand in line to buy a Bajaj Chetak. If you remember, to buy a Bajaj Chetak, it took you 3 years booking time. And today we have come to consumerism, where everything is available in abundance. I mean, you have so much choices, you really don't know what to do. But the fact remains is the manufacturers or the producers are playing on the sentiments of the consumers for the simple reason today, sir, the consumers have got a lot of disposable income. The disposable income is also creating a lot of issues where they don't know what to do with the money. Excuse me. So they are going into buying things and the competition between neighbors. That adds to the consumerism. See, if your neighbor has bought a Mercedes-Benz, then you want to buy a BMW, somebody wants to buy a Rolls-Royce. And this thing will go on, sir. And regarding, it will be very difficult to pinpoint or hold the manufacturer responsible for all this, because the manufacturer is bound to play his game. He has to exist. I'll give you a simple example. Like last time, like you said, I think it was Justice Ramakrishnan who said quit India. I mean, in March, I was in Rajahmundry, Vijay knows about it. I went to see this old pen manufacturer called Ratnam Pens. How many people are buying it today? Nobody is buying it. Nobody is buying anything that is Indian, that was good at one time, used by good people.
G.K. Naidu pen in Tamil Nadu.
Yeah,
that was very famous. Small price, good pen.
Yes, sir, but then today nobody is buying that. Everybody wants to buy a Montblanc or whatever, including me. I mean, I'm equally responsible, so I'm not putting it past me. But the fact remains is the manufacturer will play on your sentiments. And today the opulence, or the tendency to show off is so much, and that is what is creating a major problem to most of us. Right. And today, if you look at it, I mean, good luck that the software companies have come into India. There's a lot of disposable income, and you look at them spending money everywhere. You go to any mall, anywhere, you find it. It's always crowded. People are buying. I mean, nobody says there is no money. I mean, even in during the COVID times, you just open a mall for half an hour and see the rush. You will find people running and chasing. The manufacturers are playing on the sentiments of on our sentiments. And with regarding to disposable, sir, nobody takes responsibility. Nobody takes responsibility to dispose of e-waste. Why say that? So the municipality van that comes to collect will not take the e-waste even though he can, unless you pay him. You have to bribe him to take the e-waste even though he's supposed to take it away. And as it said, prosecution, the prosecution will not happen because today nobody has the time to go to court. That is why prosecutions are not happening from the consumer point of view. And prosecutions are not happening from the regulator point of view because the regulator is sitting very well ensconced. He gets his monthly cut and he's not interested. You go, I mean, anybody is caught, you go to him, there's a deal fixed, everything is over, considered closed, chapter is closed.
Monthly collection.
Yes, sir. So as it's come now in Maharashtra, it's called Hafta Vasuli. The Vasuli gang is going on. So, sir, basically for all this, the consumerism, and that is the consumers that are basically responsible. Like even amongst children, my own children, like, PlayStation 2, PlayStation 3, PlayStation 4, what did it do? Nothing much. But they wouldn't want it because somebody else had it, so you had to buy it. Otherwise, you have disgruntled children in the house. So the manufacturer is playing on the sentiments of the consumers, and that is what is going to create a problem even in the future, sir. I mean, this is here to stay, and it's not going to go away. It is very unfortunate, but it is going to stay. And the way today, there are so many manufacturers of so many goods, like they all need to sell their product. So there is undercutting, there is competition, everything is playing into the market. So somebody selling a t-shirt for 5,000, the same quality, somebody saying, excuse me, I'll give it to you for 1,000, people are buying it. And so he's saying, instead of buying one, I'll buy 5. So he's bought 5 now. Yeah, my wife is prompting, saying, you're talking of yourself. See, so this consumerism also is playing into the hands of the manufacturers, sir. So we have to curtail both. If you really, there has to be a balance, and getting that balance and equilibrium is going to be very difficult. Anyway, thanks Shyam sir, thanks everybody.
Rauji, when you have said this, I remember because when you go to the mall,
Yes,
buy one get 3.
correct.
Even your food products also goes like this, because if you go to a shop for purchasing 1 kilo of sugar for your monthly this thing, when you go to the mall, you are compelled to purchase 3 kgs. For getting 1 kg, you are getting 2 kgs free.
This is a concept that's come from the West.
And not only that, there is another rule, because as regards the Pampers and the sanitizing articles are there.
Correct.
There is a provision in the solid waste management rules. I think if I remember correct, is rule 17 or so. The generators will have to pay a particular percentage of amount of their turnover to the municipalities for the purpose of collecting these waste and dispose it of in a particular manner, in a scientific manner. I do not know, because there is a direction by the principal bench to implement this rule. I do not know how many municipalities are doing it, because if the normally in the houses, most of the waste is this, because wherever children are there, you are having the Pampers. The female are using the other sanitizing pads, etc. That is being thrown in the basket. That is not taken by the municipal people also, because saying that is not come under the plastic waste. But if rule 17 is implemented, they have got a right to collect the amount from the manufacturers, certain amount, create a fund for that purpose, and use that fund for this disposal of these things, because that will have to be used in disposed of by putting it in the incinerator, etc.
True.
But they can provide for the provision has been there. I do not know whether they are not, that is not implemented. That is a difficulty.
True, sir. True, sir.
Hospital waste also. Hospital waste also.
Everywhere. See, every day there are rules. See, it is not the question that there is no rules.
They can't be reused, no.
They cannot be. And
can they be reused?
Though the biomedical waste management rules provides for certain things, how this will not be done, etc., dealt with, etc. During the COVID period, you can see on the roads. This PPT, the code that is used are being thrown away. Every day I am seeing in the newspaper. I am taking sumoto cases. Whenever I say that every hospital is authorized, every hospital is providing the agreement with the person who has to carry it, and it is being taken to the common biomedical waste disposable facility. It is only disposed from there only. This is so much of waste that is being. I used to tell, are you verifying the amount of generation, amount which is reaching the facility? What is the gap? No answer from the regulators.
Sir, I'll give you a simple example, sir. In day before last week, we had to issue a circular in Air India. The masks are being recycled by the packer. I mean, it has come to that stage today. Consumerism or profit making has come to such a concept that the mask. So we asked a question: how do the reused masks come back repacked?
As in the case of expired medicines.
True, I agree, sir. So there is no control on all this, sir.
No,
And then
there
if I raise my voice, then I'm called a nuisance value. So that's okay. I live with it.
Prem.
Thank
the
you,
whole
sir.
difficulty is monitoring these things are very difficult because courts are having only some limited areas where you can give directions and see that is done. When
They cannot
violation again,
supervise. They cannot supervise.
It's very difficult to supervise. There is a difficulty.
Yes, we'll hear
Yes,
the,
sir.
the
If
views of
Dilip sir and Raghukumar
Prem.
sir has got nothing to add, I'll go directly to Prem.
Dilip, nothing.
Yeah.
Less
Yeah.
is the better.
Yes.
Yeah, please.
Well done. That's all.
Oh, thank you.
Answer, salute.
Prem.
Well, as you said that the plant obsolescence, that refers to a kind of focused strategical execution, which is intended to get a consumer, as Giri sir said, either to buy a new product, making this older one as non-functional, or you get it upgraded, whatever that be. And of course, what you said, it was a strategy which consciously confirms that a contemporary model of a particular product that becomes outdated or say unusable within a certain time frame, and the consumers, they go for their replacement. True, I agree with that particular thing, but at the same time, let me ask you something. See, around 25 to 30 years back, we had the small Walkman, which was later replaced by the iPods and so on. So every product, in light of technological advancements, that is bound to become obsolete, as it, you can see, it is so sure that a particular product gets replaced by a newer version at some point of time. But just because they have become obsolete doesn't necessarily mean it is not in use, because we have seen technological advancement that has, just for instance, take the case of computers. Now, old computers, all monitors, everything has become obsolete, right? We had the floppy disk, we had the CDs, everything has gone. Now, in the olden days, we had the Petromax and the kerosene lamps, which becomes obsolete when the electric lighting and the generators come. And I still remember during the older days when a bulb get fused, we used to tilt the bulb to get that filament reconnected. Now, despite we could do the same, how many of us would venture to do that? Instead, we would just throw the old one and replace the same with a new one, right? And as I said, regarding the computer, floppy disk, CDs, earlier days we used to get the films developed. We had, correct, we had video games. So now new ideas, new technologies, new devices, and a slew of new gadgets. So we have to say goodbye to many of the products which at one point of time were so staple in our lives. Now just to take the case of landline phones. With the advent of the mobile phone, the earlier phone was given a particular name as landline phone. Earlier we used to dial it. Then we had the push button type. And now see, now you have the swipe type. See, with the advent of technology and the technological advancement, something has to get outdated, like the VCR, the VCP, the audio cassettes. We don't even see audio cassettes. Now kindly see, a 512 GB of USB, right now, it is too small, just a thumb size maximum. And when this USB was first launched, I still have that, a 256 MB USB. It was almost the size of a hard disk. It was so big. Now, even if you take the case of softwares, because you have regular updates. So any software, take the case of computer or the mobile phone, whatever that be. You have Android phones, you have iOS platform like the iPhones.
Escotel phones.
Yes, Escotel, the big one, correct, the big one. Motorola. Escotel, the Motorola D160, that was the model number. I still have that phone. And
familiarity breeds contempt also.
Absolutely. And
Familiarity breeds contempt.
true, but
That
when
is
we
also
have
there.
absolutely, but when we have something like what we get in the phones, like the regular updates, that software often leaves that older hardware far behind. See, it's not only the software, we have the hardwares, which also lag far behind when the technology advances. Kindly see, we earlier had the gramophone. Now we don't have a gramophone. Everything is there in the mobile.
Yes,
Because
master's voice.
exactly, because at that point of time, it was a very simple engineering principle. And now, the more complicated this engineering principle becomes, the more linkage that it breaks. And larger components, it was often easier to make, and it was less prone to malfunction.
Storage problem
Now,
also.
correct. Now we have very small chips, which can get things complicated. And kindly see, even if it's a Chinese product, if any product which is sustained in a market, whatever be the product, be it Chinese, the product has to deliver at least an acceptable lifespan. Acceptable lifespan. Or else the product cannot sustain, whatever be its brand or whatever be its value. Because number one is, see, if a consumer is having a buying frequency, that means if he is willing to use the product as long as possible, this concept of becoming obsolete, that cannot work. Now, if we build a house, take the case of a building cannot last forever. Cannot last forever. Now, majority of the populace own the mobile phones. You can't just design a phone without a planned obsolescence, because all the components of that particular electronic gadget, it is not made to so last forever. Because right from the hardware to its operating systems to its compatible applications, you can't expect the old Motorola phone to get the latest Android 11 update or an old iPhone to have the present iOS 14 update. Because any product, this is my perception, because it is having a specific lifespan. One can never design a product which can last for 50 or 100 years. As I told you, even the strongest buildings which are constructed, eventually they need revamping. After say 30 or 40 years, or maybe 25 to 30 years, it is renovated. Now just take the case of a 2,500 square foot house which can be constructed say by spending 1 crore rupee, which may be in the present market. And if we renovate it after 25 years, that means 25 into 12, we have used it hardly for 30 months. So what is the average cost? 33,333. Average cost per month. Still you are renovating. And this excludes all the other charges, electricity, water, whatever that be. We have high-end cars. See, even if we spend, say, 500 crore of rupee to buy a new car, how many of us would use it for more than 5 or 6 years? Even though the car can last long, maybe another 20 years or 25 years. Because everybody wants to shift to a new variant. Because kindly see, even nature has its own law. See the fruits, the vegetables and other consumables which the nature gives us, only up to a certain time frame it is edible. Then it becomes inedible. So you cannot have a planned obsolescence in everything. And see, even in clothing, as Justice Surendra Mohan has put it, take the case of our clothing, irrespective of whether it gets worn out or damaged, we still keep on buying new ones according to the latest trends or the latest styles. So as far as I could conceive, the fact is that 90% of the products are like lead pencils. The more you use, the life and utility decreases. That we cannot really call it or term it as planned obsolescence. Illegal, because kindly see what are the laws. No laws would prohibit that. Section 2 clause 10.
Prem, the issue is just like tax evasion and tax management.
No, I'm just coming to that.
Is punishment.
Tax avoidance.
I will just come to that.
Just like that.
Kindly see section 2 clause 10 of the Consumer Protection Act. That defines the term defect. Right. Defect means it's a fault or an imperfection or a shortcoming in the quality or quantity or whatever that be, or in the purity or standard, whatever that be. then 2 cross 40 insofar as it relates to the goods, that would take in a seller, a distributor, and a manufacturer, or even a packer in the case of packed goods, right? But does that suffice? On the other hand, because as far as goods are concerned, we are all bound by the Sale of Goods Act. Now, if you see the Transfer of Property Act concerning the immovable property, we have a beautiful section, section 55(1)(a), which would say what are all the duties of a seller. We don't have a provision akin to 55(1)(a) in the Sale of Goods Act. On the other hand, in the Sale of Goods Act, if you see section 31, it merely states that the seller is to deliver the goods and the buyer is to accept and pay for the same in accordance with the contract of sale.
No,
And as Shyam had already read it.
As far as the movable is concerned, caveat emptor comes. You are going and
Yes,
purchasing.
absolutely. And because
Buyer beware.
section 16 of the Sale of Goods Act.
Prem, the issue is not whether the natural degradation or naturally getting.
No, it's not natural.
No. The topic of today's discussion was a manufacturer intentionally suppresses material facts and does something behind the person's back, and that is it. So
Absolutely.
Exploiting the consumerism that is being developed among the consumers.
Exactly. Fully realizing that, let me ask you, because kindly see section 31 of the Sale of Goods Act. What is the duty of the seller? It is just in a single sentence, not akin to section 55 of the TP Act. Kindly see section 16 of the Sale of Goods Act. What is the implied condition of quality and the fitness? It is merely a merchantable quality. Kindly see, merely a merchantable quality. And kindly go to section 26,
Prem,
which gives a much more interesting reading.
Prem, are you suggesting that Consumer Protection Act and other beneficial legislations will have to be read down using?
No, it's not reading.
Goods Act,
No.
No, we refer to Sale of Goods Act only to trace the evolution of law, not that we are confined by Sale of Goods Act.
No, because kindly see, because even consumer protection law, I will just come to that in a minute.
Not only that, even the Competition Act also came, replacing the MRTP Act.
Now, sir, let me ask you a simple question. In case of durability standards, you have some options. Durability standards. We cannot be blind of the technological advancements. As the technology develops, any product could become obsolete. That need not be planned obsolescence at all. See, now we have
we are only concerned with planned obsolescence, not with other things.
See, that's
perceived obsolescence. We discussed all those things.
Of course, that is why I'm asking you. Now you refer to the case of Honda CL cars versus Rohit Ji. That's 2016 or 17 ruling, which you refer to. Now kindly see, reasonableness. That was a case where he took delivery of a car and the car was more than 5 years old. And after that, the engine started malfunctioning. He went to the consumer court. And when it reached the National Commission, what did happen? Actually, the commission goes on to hold that the company cannot be held liable. Another case is that of Maruti Udyog, another 2007 judgment. Because here you cannot have, see, after a particular period of time, because any product that can have a reasonable lifespan, you cannot expect a product to last 100 years because technology is advancing.
Prem, again, you're missing out on the point in the sense like we are not on that. What we are saying is that can somebody intentionally do something to reduce the optimum otherwise available life, etc., and deceive the consumer? If so, what are the remedies available? That in short was the, discussion centered.
See, earlier when we go for the BPL TV, a bigger one, I used it for nearly 10 years without any difficulty. No replacement, nothing was required. Some small repairs, something comes, it was usable. Now became, if you go for the thinner versions of these, so many new technologies, even after 6 months, it is not having the life sometimes.
Whether it is deliberately done is the question.
Yeah, that's one. Deliberately not making available parts, etc., so that repair can be done. We are only on that, not other things we know. Even I'll just ask you one question.
Whether it is part of a strategy.
What is the difference? Prem, 1 second. What is the difference between a terminally ill patient and a healthy man? Both are dying. one person is aware, the other person is not aware. I just
No, no,
want to
let-
know whether my product is dying. You tell me and still I purchase, I'll suffer. But you don't disclose. You deceive me. That is my equation.
No, see, kindly see. This thing, because take the case of a gadget as an example. Because see, it is made up of various components. Do you mean to say every component has to last lifelong?
What is the point you're trying to make? What is the point?
See, I would just tell you, planned obsolescence, as far as the Indian laws are concerned, we have absolutely no laws that would prohibit. Because I was also clueless on this subject. And finally, I could lay my hands on a legal studies research paper. But it was, of course, it was a foreign paper, the University of Florida. And they have done a very great research about this, taking into consideration almost every law across the globe. And it's a must read. Almost everything has been addressed in
And
detail.
ultimately, what was the conclusion? Whether they require a law or not a law?
If we
No, sir,
have
we
a law,
require a law.
no, sir. If we have a law, of course it is illegal. But see, what is the meaning of the term illegal? If it runs counter to law, it is illegal. If you don't have law, how can you call it illegal?
There again, what we placed for deliberation was that the existing law, if properly interpreted and used in a proactive manner, might be sufficient, even though it does not take away the need for what do you call?
Definitely, because the existing laws cannot take even a fraction of this.
Absolutely. The legal landscape may be insufficient. Our endeavor is to proactively make it more effective.
Of course, because see, everything that needs to be within the legal framework, and whatever is within the legal framework, it is legal. Whatever is outside the legal framework,
No, not that. See, the attempt is whether something can be made
Under the existing law.
or some provision can be added in the existing law regulating these aspects also, because competition authority act, I think that something is done in that, it can be done. It can be done.
To a certain extent, competition.
But
competition
there are inherent problems in that.
Absolutely.
See, every manufacturer will say that we are bringing out an improved version.
Correct. And
we are not exploiting the consumer.
And that apart, sir, because majority of the customers, they go for an upgrade. So automatically the older versions that is being used by hardly say 10-15%.
Maybe it is by a process of indoctrination of the customer.
If it is a free volition of the consumer or the customer, it's okay. If it is being manipulated, should we not step in? What are the ways and means of stepping in? That was the threshold of the discussion.
I'm asking you, see, manipulation means you are having warranty for any product. Then you are having extended warranty, right? Because see, we have pros and cons.
That is where we stand. It is not one-sided.
Exactly, because when we stand in the shoes of a manufacturer or that of a trader, then you can view it in some other perspective, because you cannot.
Absolutely.
Shyam, if you incorporate that self-service clause.
Right to repair.
Right to repair. They will say that you have tampered. You have been tinkering with the object, so that it is now beyond our control. So it may be false. It may be a false defense.
So they will say that, or on account of a misuser also they will say.
Yeah.
No, that's that all has to be discussed in detail. We are fringing on 8 o'clock, but still I just make one comment, sir. We were talking about this right to repair after the so-called warranty guarantee period.
Yes.
That stands the test of reasonableness. I mean, reasonable period. That was what was pondered over by the National Commission in that Maruti Suzuki case of 2007 and the Honda CL case of 2017. Reasonable time frame.
Correct.
That, of course, the court is having ample unbridled powers. It's for the court, of course, but not for an unreasonable time frame.
No, we are only asking for reasonable treatment of all the stakeholders.
No, merely because it is in electronic goods, it is depending upon the luck of the person who is purchasing it. His longevity will end in difficulty for a consumer.
That is also there. Same model, you take 10 pieces. One piece may malfunction. It is not deliberate. may not be deliberate. Take 10 pieces of the same model. One or two models may malfunction. Beyond the control.
What Ramkumar sir said is absolutely correct. Because last month, I bought two phones, one for my wife and one for me. Same models and high-end phones. Mine, it is malfunctioning. And it's a high-end phone. Kindly see.
Yes.
I'm unlucky.
Any secret manipulation by your wife?
That we'll discuss
No,
later.
not that. No, if it happens to is her one, she can demand for a new one. Suppose it happened to Prem, she will not finance it.
Okay, Prem, let us wait.
Well, anyway, very vibrant and wonderful subject.
And for the concluding remarks and a vote of thanks, I request Advocate S. Raghukumar kindly propose a vote of thanks.
Raghukumar sir is relaxed and sitting, and now he'll be shocked.
He was about to leave or about to
go for dinner. Go for a dinner.
Already declared that you have done well. The new subject you have dealt with all the well articulated and in an inimitable style, Shyam style. Shyam style, only one person you can claim, because my style is applicable to so many people. But still, Shyam, you have done it well. More, and everybody has started the thinking process. Everyone, including judges. Only Shyam can do it. And that is enough. Okay.
So he has made us think.
Thank you, Raghukumar sir. I think Prem and you would have conspired to make the statement, but anyway, thank you very much. Let me, while we come to the end of the 211th session, tomorrow in the 212th session, we have Justice K. Kannan, former judge of Haryana and Punjab and Haryana Court and High Court. He will be dealing with the subject, new tools of advocacy in the changing times. That is tomorrow, 5 o'clock. So let me once again thank in absentia Justice Giri. He has sent a message that he has to attend a meeting in the Supreme Court Bar Association. Justice Surendra Mohan sir, thank you very much sir for your valuable presence and inputs. Justice Ramkumar sir, Justice Ramakrishnan sir for the active interactive sessions, and all of you wonderful participants for being part and parcel of this 211th session, wherein we could deliberate and discuss on a new topic. And let us utilize this opportunity to bring in newer topics, and any one of us can introduce the subject, then we can deliberate over it, so that we'll be conscious that things like this also exist. And our thinking, like all of you today mentioned, that kindle the thoughts in our minds, so that we'll also think in terms of what are these and what are not. And Prem will always be there to contradict whatever you say, so that it will make even more interesting and entertaining and engrossing. Thank you once again. Until we meet again tomorrow at 5 p.m. in the 212th session, please do take care and stay safe. Thank you.